today's video and podcast episode of Legal Scrubs. Today I want to talk to physicians who are curious about or want to learn more about how non-competes work with respect to their practice. And I'm limiting this discussion today to Tennessee law, and in particular I want to talk about the Tennessee Statute that deals with non-competition covenants and agreements with respect to doctors and other healthcare providers. TCA, which is Tennessee Code Annotated, Section 63-1-148, is the statute that addresses the enforceability of non-competes that doctors typically enter into when they sign employment agreements with their practices. What TCA 63-1-148 essentially says is that a non-compete that is signed by a doctor is deemed reasonable if the time restriction on the non-compete is 2 years or less, and the geographic restriction on the doctor is the greater of 10 miles from the practice site where he or she practiced, or the county in which the practice site is located. Or, in the alternative, if there's no geographic restriction, if the non-compete provision restricts the doctor from practicing at any health facility at which the practice used or practiced at during the time that the doctor was a member of that practice, that is also deemed reasonable under the geographic restriction language of the statute. So in essence and in summary, the Tennessee statute deems reasonable non-compete provisions affecting doctors as long as the non-compete is not for more than 2 years and the geographic restriction is not greater than the county in which the doctor practiced or 10 miles from the site, or in the alternative, if the restriction restricts the doctor from practicing at any health facility at which he or she practiced or the employer used during the term that doctor was a member of that practice. So the fact that that statute's out there, what does that mean for a doctor who wants to leave or does leave a practice, and they have one of these non-compete provisions that, let's say, is 2 years or less and is 10 miles from the practice site, or is in the county in which the doctor practiced, or prohibits the doctor from practicing at hospitals or other health facilities that the practice utilized during the term that the doctor was in that practice. Is that non-compete always going to be enforceable? Does the statute make it always enforceable against the doctor? And that's a great question. There are only a couple of cases that have been decided since this statute was put in place in 2008, neither one of which really answer that question. But if you look at general law dealing with non-compete provisions in Tennessee law, what you find is that courts want to construe or interpret non-compete provisions very strictly. Non-compete provisions are restraints of trade, and so they're disfavored. They will be upheld if they're enforceable according to their terms, but courts tend to construe them strictly against the employer if at all possible. So if you have a non-compete provision that meets the requirements of TCA 63-1-148, is it always going to be enforceable? And the answer to that question, like I said, is not really clear from the Tennessee law that's out there. But if you look at other cases dealing with general covenants not to compete, you find that in order for a employer to be able to enforce a non-compete, that employer has to have what's called a protectable business interest or a legitimate business interest in enforcing the non-compete. In other words, non-competes are not intended to stifle or restrict all competition, just unfair competition. And so an employer needs to have a protectable business interest to keep a former employee from competing with that employer. Now, what makes a protectable business interest? Well, case law essentially lays out three possibilities that would give way to an employer having a protectable business interest. One is, did that employee have access to trade secrets or confidential information? Number two, did that employee receive specialized training from the employer to enable that employee to perform its services? And number three, is that employee or was that employee the face of the business, face of the employer during the term that the employee worked for the business? In other words, did customers, and in the case of health practices, did the patients of the practice see that employee, that doctor, as the face of the business, the face of the practice? Now, let's take those one at a time. Did a doctor receive specialized training in order to perform his or her services? Well, that may not be the case in a lot of circumstances, because doctors come fully trained to provide medical services when they join a practice. They've gone through medical school, they've gone through internship, they've gone through residency, they may have practiced already, but in any event, they are doctors with the knowledge and skill to provide medical services. Does the practice give them specialized training to enable them to provide services to patients? Arguably, no. That would certainly be an issue if it came up in a case to see if a non-compete could be enforced. So let's just say that one might be difficult for the employer to prove that it provided specialized, unique training to its doctors and to enable them to provide their medical services. The second issue would be whether or not that doctor had access to confidential information, trade secrets of the practice. Now, in some cases, the doctors are going to have that access. If they are partners in the practice and they see a lot of inside information about the practice, and that's the kind of thing that the practice would want to protect against that doctor being able to go out and compete with that trade secret or that confidential information, give them a leg up in competing with the practice. It might be under certain circumstances that would be the case. But in other cases, it may be not the case. It may be that doctor did not have access to confidential, inside, trade secret kind of information. So the last one is, did that doctor essentially become the face of the practice with respect to its patients? Now, if you were in a practice and you were the sole doctor who provided a certain kind of services, like you were the only gastroenterologist in your practice, or you were the only pediatrician in your practice, or you were the only radiologist in your practice, or whatever specialty, it might be that to the patients of the practice, for those services, you were the face of the practice, and that might give an employer a good argument to enforce the non-compete. But if you were in a multi-disciplinary, multi-specialty practice, and you were one of many perhaps, doctors who provided the kind of services you provided, you might not arguably have been the face of the practice to those patients. And so again, that's something that would be a question of fact in the event that you chose to leave a practice and wanted to contest the enforceability of a non-compete. Now, going back over just as a summary, Tennessee law does deem reasonable covenants not to compete or restrictions against healthcare providers, doctors included, whose non-competes are limited in time and scope, geographic scope, to 2 years or less, 10 miles or the county in which the practice site was, whichever is greater, or in lieu of a specific 10-mile or county restriction, a restriction against providing services at a health facility at which the practice provided services during the term of the employee's practice. Now, what does it mean to be deemed reasonable? I think there's a good argument out there that really is a deeming reasonable of the time and geographic duration of the restriction. not that the restrictions themselves cannot be challenged as unenforceable because the practice did not have a protectable business interest. So if you are a doctor who is under a non-compete and you do want to leave or you have left, there may be a question about whether the non-compete is enforceable against you, and it may come down to the actual facts of your case. It may be that the non-compete on its face meets the language of TCA 63-1-148, but it may be that even though it does, you did not get specialized training, you did not have access to confidential trade secret information, and you were not the face of the practice to the patients. If that's the case, you have an argument that the employer does not have a protectable business interest in enforcing the non-compete. So that's just something for you to consider, keep in mind, look into if it's your situation. Okay, I hope that helps, and we'll talk to you again next time.